Hello, this is Arkansas attorney Mark Robinette. Welcome to another video in my series Arkansas Probate Basics. Today's video we're going to talk about the Affidavit for Collection of Small Estates. This is part 1 of 3. In this video we're going to go over what is an Affidavit for Collection of Small Estates, how is it different from a standard probate, and what are the simple or undisputed requirements to obtain the affidavit. First of all, what is it? Well, like all things in the probate code, it's a statutory remedy. You can find it at Arkansas Code Annotated 2841-101 if you want to read the statute. The legislature enacted it as a streamlined means to administer states with little property. How is it different from a standard probate? Well, the filing fee, first of all, is only $25 versus a filing fee of up to $185 for a standard probate. A standard probate, of course, is a civil action which requires the full $165 civil filing fee. In counties with electronic document recording or electronic filing, it's an additional $20 technology fee, so you could pay up to $185 to file a probate in one of those counties versus just $25 no matter where you are for the Affidavit of Small Estates. This requires a single court filing in the form of an affidavit. It's a very simple document. It has certain recitations that have to be made, which are all found in the statute. A standard probate, on the other hand, we're talking about a petition, we're talking about waivers, we're talking about accounting, orders, any number of things that have to be filed. They're very difficult for a lay person to understand. So more documents, you're talking about more attorney's fees. So you'll find that an affidavit of small estates, where you qualify for it, is definitely worth the time and consideration to do over a regular probate. So what are the simple or undisputed requirements? Of course, because this is a statute, it's not a perfectly drafted statute, and until there's sufficient case law about it, there are of course risks to consider when going this route. Well, the easy ones are 45 days since death. That's pretty hard to contradict. No unpaid claims against the decedent or his estate. In other words, there aren't any bills lying around, any known debts. No demands against the decedent or his estate. So a demand is quite different from a claim. A demand is a debt that has not yet been reduced to a judgment. So it could be for anything from a breach of contract to maybe the deceased was in an auto wreck that he or she caused, and there's a pending demand for that claim. So those are the simple and undisputed requirements. The differences between a affidavit of small estates and a standard probate, and just what it is. In our next video, we are going to discuss some of the more difficult requirements, or at least the ones that are harder to understand because of the drafting of the statute. Thanks for tuning in. Check out part 2.